Hello, we are Unit 5. We focus on rights given to us by the Constitution, specifically the right to freedom of speech and expression. My name is Emma.
My name is David.
My name is Anna.
I'm Ryan.
And I'm Charlie.
Great. Nice to meet you all. So your question today is, the First Amendment states that laws shall not be passed that abridge the freedom of speech. Why did the founders think freedom of speech was so important? Do you believe there are times when freedom of expression should be limited? Explain your response. Should a public speaker who calls for violent action be protected by the First Amendment, whereas an audience member who performs the action should be sent to prison? Why or why not? May begin.
The First Amendment of the Constitution states, Congress shall make no law abridging the freedom of speech, of the press, of the people to peacefully assemble. These all fall under the same category as freedom of expression.
The main founders of the Constitution thought freedom of speech was very important. They came from a place where the law of the land was that freedom of speech was limited because you were not allowed to speak out against the government. The original version of the Constitution didn't defend one's right to freedom of speech. It was added in the First Amendment. Also, in the colonies, the colonists didn't have any representation in English Parliament. This influenced the founders to emphasize freedom of speech while developing independence.
Our founders' strong feelings for First Amendment rights in part came from their experiences in Britain. In 1215, when the Magna Carta was signed and went into action, it did limit the power of government. However, it did not give the citizen any additional rights and provided limited protection of the right to freedom of speech. In addition, bad-mouthing British government could still be considered treasonous and result in serious punishment, very similar to John Adams' Alien and Sedition Acts. Having the experience of slightly limited speech rights and receiving either further limitations in the colonies made them so passionate about this essential human right.
Although we do have a broad freedom of speech in the United States, it has been limited and challenged throughout history. For example, during the Civil War, Southern states banned abolitionist publications. And even today, government can implement time, place, and manner restrictions on our freedoms of speech, press, and expression. For example, you cannot parade down the street naked and blowing an air horn at 2 in the morning because this disrupts the public peace and infringes on other people's rights. This ties into the concept of social contract and safety versus liberty. On the other hand, in the case Gitlow v. New York, the Supreme Court held that freedom of speech rights have to be acknowledged by both state and national governments, expanding the protections on our general freedom of expression.
Freedom of speech and expression sounds like speech should be and is completely free. But what would happen if people were to just holler out what they wanted to? What would happen if somebody screamed fire in a crowded movie theater? It would cause bodily harm to others as they would trample over each other, desperately trying to evacuate. Or should the Westboro Baptist Church be able to stand and yell about how God hates soldiers during a veteran's funeral, like in the case Schneider versus Phelps? For this exact reason, the freedom of speech and expression should be limited. People should have the right to criticize the government, but not by starting a riot. We should have the right to stand up for what we believe in, but if it is not causing anyone bodily or mental harm.
When a person actively encourages a crime, they shouldn't get charged like the person carrying out the crime. One's words can have more of an impact than one's actions, but action speaks louder than words. Groups like the Western Baptist Church go around spreading hate, saying God hates fags. But they don't get in trouble for that because they are protected by the First Amendment. Although I feel like speech can lead to violent action, government should not infringe on our rights to freedom of speech.
There are several occasions where a public speaker who calls for a violent action is protected by the First Amendment, while an audience member who takes action is sent to prison. The suspect of the Boston bombing made a bomb with instructions posted on the internet and was charged with a crime. So should the person who wrote that instruction on how to make the bomb on the internet also be charged with aiding in the bombing?
Though we do have a broad freedom of speech, sometimes there has been limits on this important right. However, the freedom of expression should stick to its name. As George Washington once said, if freedom of speech is taken away, then dumb and silent we may be led, like sheep to the slaughter.
All right, thank you very much. All right, so first of all, question. And so I'm trying, before we start, is it Ryan and Charlie, or which one's
Ryan. I'm Charlie.
Ryan and Charlie.
All right, good. Okay, so Charlie, to follow up on your interesting comment about Boston, bomber and searching for things and research on the internet, should it be lawful to put information on the internet about how to make a bomb? Why or why not?
I believe that people should be allowed to put stuff on the internet about how to make bombs and stuff because, like, let's say a kid is doing a science project on like how bombs work or whatever. They can go on the internet, look up how it works, like all that. And I don't think it's the person's responsibility that put the instructions up if someone else just goes out and actually like harms people with it.
So I'm going to try and push a little bit. So say if you're the person who happened to write those instructions and then the Boston bomber used your version of the instructions to build that device that caused harm, should the person who drafted or put that information, could they be held liable? Do you think they should be prosecuted? What do you think?
Well, they should only be prosecuted for this if they were actively encouraging the Boston bomber to commit the act. Like if they were emailing him over and over again saying, "Do it, come on, you need to kill people," then of course they would be encouraging, and actually there would be a cost to this because the bomber would feel pressured to do it. But however, if the person who wrote the instructions didn't say anything to the Boston bomber, and he wasn't in any way associated with him, he shouldn't be charged with the crime because he only posted the instructions. He didn't actually say to do it.
I think in some instances, actions speak louder than words, and this is a prime example of that. In some case in California, I'm pretty sure, a leader told people to dress in purple like robes and kill themselves because the world was going to end. And he had such a powerful influence on the people that they killed themselves. And because of his influence, he was held accountable for their deaths.
All right, so in the case Tinker v. Des Moines, they severely limited a student's free speech rights in their schools. Do you think that it's appropriate to limit those free speech rights? Like, do you feel like you don't have enough speech in your school? Do you think that that's necessary?
I do. I think that freedom of speech in the schools is actually very important to get students actively participating in expressing their feelings in society. And throughout the years when people have tried to express freedom of speech as kids in the adult world, for example, Tinker v. Des Moines, or all the way up to the Texas v. Johnson case in '89, it's always been relating to, they're going on the very liberal side of free speech. So I think that as an adult, they're not going to get in trouble for it, so why should they be limited in their younger years if they're going to be able to express it later on?
I think that the main purpose of school is for learning, and if the students are disturbing the act of learning, then they shouldn't be able to wear the armbands.
I agree with David. In the case over the NRA t-shirt that a boy wore to school and was suspended, the only reason why he was suspended was because he was wearing a shirt that could cause controversy and could cause a disturbance. However, the next day, some of his friends wore the exact same shirt and weren't punished. So.
You guys brought up the case Schneider v. Phelps in your prepared statement. Can you guys maybe explain a little bit about that case and how you would rule in the case if you guys were on the Supreme Court when it was decided?
Well, basically what happened was there was a veteran who had died overseas, and the Westboro Baptist Church, they believe that soldiers that are dead are, they're a way of God showing how he hates America. And so they were protesting at the funeral, because at the funeral they were respecting the dead soldier, but the Westboro Baptist Church was saying thank God for dead soldiers and just being very disrespectful and disruptive. And so I think the father of the soldier who had died tried to sue the Westboro Baptist Church, but the Westboro Baptist Church was protected by the First Amendment, saying that they had the right to freedom of expression. There were time and place manner. There might have been, they might place time and place laws so that they can only protest an hour before or an hour after the funeral.
And 500 feet away so that the grieving family wouldn't have to see them as prominently as they would if they were right next to the casket.
And just adding in the original Snyder v. Phelps case, the ruling of the Supreme Court was 8-1 on the side of the Phelps family, so there wasn't really, they weren't even close to winning the actual case. But they did get a lot of publicity out of it, and now the Westboro Baptist Church is one of the most hated.
When do you think it's appropriate to put time, manner, and place restrictions on freedom of speech?
I think it's important to put time, place, and manner restrictions on freedom of speech if it infringes on other people's rights or disrupts the public peace. Like in the Westboro Baptist Church, they had to protest 500 feet away and an hour before or an hour after, and that would make things at the funeral go a lot smoother than if they were right next to the people.
And we're at time. Nicely done. Sorry, Sage. All right, so follow-ups from colleagues.
I thought that you handled the distinction of like providing information or, I guess, broadcasting, like encouraging people to commit crimes. Like the distinction there, I thought that's a very fine line, and you walked that very well. And you handled that subject with a lot of knowledge. So I really liked that.
All right, so I, right off the bat, was impressed by Charlie's comment in the prepared answer that the Bill of Rights wasn't in the original Constitution, that it wasn't originally provided for, because that is something that I did not understand until partway through Constitution Team. I didn't realize that the Bill of Rights wasn't published at the same time that the Constitution was, and so I thought that that was really great and showed a deep understanding. And then throughout your prepared answer, you knew what you were talking about, and you had good citations. I liked that you're talking about the Boston bomber, and like Calvin said, your distinction that the person who put it on the internet, unless they were trying to influence the bomber, that they shouldn't be held responsible. And I agree with that, because I think that you have your own ability to decide what you're going to do. So I thought that that was a really interesting and very applicable example.
Ryan, you did a great job with the examples during your free speech in schools. Just a bunch of great cases, half of which I'd never heard of. Just a really good job how you really knew the cases and you really knew how they're applicable in free speech. You guys answered my question about Snyder v. Phelps very well. Great job, and how you would rule on it. It was a great job how you guys brought it together. You knew what the ruling was on the case, and you knew what the case was about. And yeah, you guys did a great job overall.
Okay, before Mr. Trombley goes, I just want to say one more thing, which is what I would have asked had we had more time. Since we talked a lot about schools, I was going to ask about, you mentioned Texas v. Johnson and the flag burning case, and how far free speech should go against our government. So just something to think about.
I'll again echo the comments that have been made previously, but I want to highlight some specifics. I think with my first question, I thought it was a really nice, what I would call a 1-2 punch between Charlie's first response to my questions and the follow-up with Emma going directly to the notion of if content and the owner of that content is actively engaging a specific individual to commit an act. That distinction was smart and spot on, and that's a distinction that's not very clearly delineated. So the fact that you both can do it both well, nice teamwork, but also nice understanding of that particular issue. Ryan, with your comments specifically around the number of court cases was really good and very specific, which I liked. But also especially the fact that highlighting the issue around Snyder v. Phelps was in the end that it was an 8-1 decision, that there was no legitimate way possible, that case was going to be won in favor of families. The other thing that I liked from your prepared statement was the drafting of what ended up in the First Amendment. So kind of highlighting how those issues back then kind of informed what our beliefs now about the First Amendment, what should be in it, what should not, what should be protected, what should not, under what circumstances certain things should. So I think that was a nice way to kind of also tee up what the broader dialogue was going to be. And I think from that part of early on in the prepared, it nicely flowed out to what was both prepared and followed, which was everybody brought in a particular point of view, a specific Supreme Court case, but going back to answering my or one of my colleagues' questions, but really hitting home what kind of the challenges and the issues are. But what I liked also from your answers overall was the fact that you guys really understood and were able to struggle with what are the intricacies of under what circumstances things can be applied and which cannot, and knowing how each piece fits into that puzzle It's not an easy task, so I think that the ease in which the 5 of you can do it is very nicely, it's very well received, so thank you.